All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too.
You got 5 minutes.
Well, I don't need it. I want to continue.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt.
This RICO trial blew up. The judge stormed out, a defense attorney was thrown in jail, and in a twist no one expected, the judge was kicked off the case. What started as a trial turned into a full-blown courtroom meltdown. The case against Jeffrey Williams, aka Young Thug, stretched over a year, with some of the wildest moments imaginable. The biggest? Lead defense attorney Brian Steele was sent to jail. Prosecutors said Williams co-founded YSL as a violent street gang. The defense insisted it was just a record label. Then came the bombshell. Steele was accused of hiding knowledge of a secret meeting between the judge, prosecutors, and a key witness. When he refused to give up his source, the judge stormed out, held him in contempt, and had him locked up.
There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file.
To be able to play though?
To be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it.
Defense attorney Brian Steele did not take kindly to prosecutor Adrian Love's remarks, immediately objecting and pushing back.
You allow another moment when Ms. Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful. I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They had everything that we got from the Fayette County jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time. Okay. And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
I'm
attacks?
speaking.
Really, could we strike that?
Okay, hey, everybody, calm down. Everybody, both of you, please be seated.
Judge, I'm not
Both
done.
of you, please be seated.
You have to do something.
Wow. I don't know Mr. Steele personally, but from watching this trial, you can see he's passionate, unafraid to make his point, and even willing to challenge the judge. This wasn't the first clash between Steele and Judge Ural Glanville, and it definitely wasn't the last. After that encounter, Steele dropped a bombshell. He told the court he'd learned of a private meeting in chambers between Judge Glanville, prosecutors, and key witness Kenneth Lil Woody Copeland. Copeland's name has surfaced before. His leaked interrogation video appeared to implicate Williams, and prosecutors granted him use immunity, meaning his testimony couldn't be used against him by the state. But according to Steele, in that meeting, Copeland allegedly confessed to killing Donovan Thomas, the 2015 drive-by victim at the heart of this case. Prosecutors have long argued Williams rented the car used in that shooting. Steele also claimed Assistant DA Simone Hilton told Copeland, who had just pled the Fifth, that he could be kept in jail until all 26 defendants' cases were resolved, which could take years. Steele called it a direct threat. Here's the problem. Ex parte meetings, where the judge meets privately with one side, are a serious red flag, especially in criminal cases. Defendants have the right to be present when exculpatory evidence is discussed, and having a sworn witness in a closed-door conversation with the judge, that's the kind of thing that can shake an entire trial.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, We did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. And then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have his. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you
perjury.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information. Then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why did
Sir, I'm going to hold you in contempt if you don't tell me who that. Tell me who this information was.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you what,
I'm going to give you 5 minutes. If you don't tell me,
if
you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Okay, so the judge called a 5-minute recess. When he returned, he demanded to know how Steele found out about the private chambers meeting and what was said. That's when things got complicated. Steele essentially told the court, "Judge, you're putting me in an impossible spot. If I reveal my source, I violate my ethical duties."
Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at Comment 5, this is how I understand the law.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you.
You're
threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sum substance, but I'm telling you I can't do that under the bar rules.
All right. Well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea may be wrong.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can talk.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have
information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
Prosecutor Adrian Love actually asked that Steele be allowed back into the courtroom for the rest of the day. The judge eventually agreed, but later turned to the contempt issue. Steele was represented by Ashley Merchant, a prominent Atlanta defense attorney who recently fought to have DA Fani Willis removed from the Trump Georgia case, along with attorney Alex Susser. They argued that if Steele was truly in contempt, the court had to hold a hearing. Merchant pointed out the distinction between civil and criminal contempt, stressing that if it was criminal, due process required a hearing before a different judge, since Glanville himself was a witness in the matter. Judge Glanville disagreed.
Is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, with criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was.
Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person.
And
okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
But the best bit, Merchant told Judge Glanville that 25 attorneys from the Georgia Association of Criminal Defense Lawyers were right outside, ready to represent Steele. Glanville shot back there was no room for all of them. Merchant suggested the jury box. Glanville flatly refused. Meanwhile, Steele was getting major support online, especially on X, where many in the legal community said he was in the right. After that, the judge called for a short break, which stretched into more than an hour before court finally reconvened Monday night.
Mr. Steele, I am going to still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024 at 7 p.m., subject to further order of this court. And that will be entered and e-filed, and you may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you, sir. I will, sir. If that comes to pass, you have my support. I will talk with our sheriff, and we may be able to make that work. Okay.
Judge Glanville ultimately signed an order finding Brian Steele in direct criminal contempt and sentencing him to spend the next 10 weekends in jail. Almost immediately, a motion was filed to set aside that contempt order. In it, Steele's attorneys relied heavily on Georgia Bar Rule 1.6, which requires a lawyer to maintain the confidentiality of all information obtained in a professional relationship. Importantly, The commentary to that rule makes clear that confidentiality applies not only to matters communicated directly by a client, but also to any information acquired in the course of the professional relationship, regardless of the source. That, they argued, is why Steele could not be compelled to reveal his source. The appeal also emphasized that only hours after holding Steele in contempt, the court declared he could purge himself of the punishment simply by disclosing where he obtained the information. This, they argued, amounted to an illegal and internally inconsistent sanction. They further noted that because Judge Glanville was personally involved in the events at issue, he was effectively a witness, and therefore should have recused himself, allowing a different court to handle the contempt proceedings. In the end, the appeal prevailed. Steele has not served a single day in jail, and Judge Glanville was removed from the case. Just a wild turn of events. If you enjoyed this video, don't forget to hit that like button and subscribe for more updates.